Any mentions?
Good.
I'd like to mention item number 8. Lordship, I am for respondent 2 to 6, appearing on behalf of Senior Standing Counsel of Income Tax, Mr. S. Chetia.
Number 8.
Yes, Lordship.
Number 8 is over in the Supreme Court. It's been decided.
Lordship, it's still pending.
Then? When's the next date?
Well, the date is not fixed before the Honorable Supreme Court as yet.
Then?
It will be probably in the month of March. So
take down as reported matters in pending consideration before the Honorable Supreme Court just after 8 weeks. Yes.
my lord, the stay may continue, my lord.
Stay if any should continue. Interim order any cut till next date. Yes.
May I please also, I'd like to mention item 7 also. Here,
7
Lordship,
related to 6, correct?
yes, Lordship. Here, Lordship, this senior counsel is engaged to argue this matter, Lordship. As of today's
Which senior counsel?
HL Shanghai Soul, Lordship.
He was arguing this matter from before, correct?
Yes.
Or is it
Lordship.
newly engaged?
Yes, we were engaged earlier, we were disengaged, and we were engaged again, Lordship. So,
Then
as of today, Lordship, there is a difficulty as he's out of station, Lordship.
6 and 7, your lordship.
Apply, Your Lord.
Your
After
lordship,
10 days.
in item 6, we would like to file a substitution, your lordship, as the president of the
Who's appearing?
In item
Yes,
6,
madam.
I'm
Item
appearing.
7, I'm appearing.
7 year appearing?
Yes.
6.
6, I'm appearing, your lordship,
You put an application, we'll consider.
for substitution, your
You
lordship.
put an application, you file an application.
Mature, your lordship.
Apply, your lordship.
Item number 1.
What is this?
May it please your lordships, by way of this writ petition, the state is seeking to challenge certain show cause notices, orders and demand notices by the respondent, Deputy Commissioner of Income Tax, DTS.
Serve notice on income tax. They are standing counsels, I suppose.
Yes, my lord, we have. My lord, we have not yet given them copies.
Then?
Given copies, my lord.
Well, one thing, Mr. Day, how do you seek to sustain this writ petition?
Lordship, on 2 grounds, two ostensible grounds. The first ground is on the basis of jurisdiction. One of our arguments, Lordship, is basically that the assessing authority does not have jurisdiction to issue the show cause notice in the first instance. Primarily,
Well and good. Now, you see, I was just looking at the cost title.
please.
It says that you first, in the first cost, it says application under 226, fine. And next, an appeal on section 260A1. How do you reconcile these two things? Appeal section 2601 against an income tax appellate tribunal.
Lordship, if I may,
Come from the orders of the CIT.
if I may, Lordship, there are 3 grounds upon which we are challenging that order.
Because you have to cross the threshold of whether it's
Under 226. And if your lordship might permit me, the first ground that we're taking is basically absence of jurisdiction to actually issue the show cause notices against the state in the first place. The state not being a person under the Income Tax Act or a
far back as 6 years ago, 7 years ago.
Lordship, I have a response to that as well. The last demand notice was issued in the year 2025. In the interim, we were trying to sort out the entire affair with the respondent authorities to no avail. So left with no choice. The last demand notice, in fact, was issued in the 5th of December 2025, very recently, Lordship. In the meanwhile, we were trying to sort the issue out with the authorities.
And the only thing is that, see, in your case, appeal under section 260, arising out of an order 76 of 19, by the Deputy Commissioner at the Now, against an order of Deputy Commissioner, you have to go to the CIT and appeal.
There's an appellate process. I bow down before your lordships.
Appellate tribunal, only then 260 will come to play.
But
it doesn't come to play now.
But my lord, but if your lordships might permit me just 2 submissions. The 2 submissions before your lordships are not something that's appealable. The first submission is as to jurisdiction, whether the authority actually had the jurisdiction to issue the show cause notices against the state, not being a person under the Income Tax Act and therefore not being a assessee in default, whether they had the jurisdiction to do that in the first instance. That's my first submission on jurisdiction, Lordship, which is why we come under Article 226. My second submission, Lordship, is if you look at the facts of the case. The fact of the matter is they had issued a show cause notice to us. We had replied to the show cause notice, but in their subsequent order, they said that we had made no submissions to them at all, which was completely contrary to the facts of the case. We had. So that invokes the question of legitimate expectation and natural justice. They had not taken our submissions on board, which is why, again, Lordship, we have approached this Honourable Court under Article 226. On those two grounds. There are other grounds which are more appealable grounds, admittedly, Lordship, but those two grounds are bring this matter under.
In any ground you can appeal. I mean, they are free to look at any aspect of the matter.
But Lordship,
whether you're a what do you call
Lordship, this raises a substantial question of law whether the state can be a person under the Income Tax Act. It is a pertinent question which only your Lordships under 226 will perhaps.
260, the appeal, when it's filed against income tax appellate tribunal, it's only a substantial question of law. So that's the thing. I understand the difficulty.
Lordship.
A hard hill to climb. That's the only thing. But you just serve notice in income tax and will
please, Lordship.
After 1 week. Yes. Yes. Heard Mr. ESD, the conservative petitioner, stop issue notice. As there's the standing counsel here, standing counsel there, the counsel that petitioner directed to serve notice upon his counsel. This up to 1 week. Yes.
Please, Lordship. Grateful.
Item number 2.
Yes, affidavit.
It's for affidavit. I'm praying for some additional time. I've received a paragraph. Maybe 2 weeks time I'll file it.
Now what about the central board and direct taxes? They have accepted. Are you appealing for them also? Number 5.
No.
You have not taken fresh step on number 5?
No, Your Lordship,
Why?
the petitioner has not sent me the copy, Your Lordship, till now.
Then you are appearing in which capacity? Without briefless capacity? Without the papers with you?
No, Your Lordship.
Yes, Dr. Muzika appears for and allowed for the 2 weeks time to affidavit. Stop. You are Mr.
D. Das, Your Lordship.
Mr. Didas. You appeared last time also.
Yes, Your Lordship.
Is directed to take fresh steps on the respondent number 5 within 3 days. Just
3?
after 3 weeks.
3.
3 are not there.
Your Lordship, the respondent is not present, Your Lordship, in this one. They were coming, they were able to confirm the VC.
Who's the respondent?
VK Thakur, Your Lordship.
They can't come by VC, meaning?
Your Lordship, they were able to confirm the VC, but nobody is present, Your Lordship, here.
What stage does it matter?
Your Lordship, they will also file the affidavit.
They have not filed affidavit.
No, Your Lordship.
Last time none appeared for respondents also.
No, Your Lordship.
B and Gogoi.
Yes, Your Lordship.
Mr. Didas is present on behalf of the petitioner. Stop. Today also there is no appearance on behalf of the respondent. Stop. It is also noted the affidavit is yet to be filed by the respondent. Stop. A list after 2 weeks in the event that there is no appearance next day, the matter shall be taken ex parte.
Much obliged, Your Lordship.
4.
2 and 4 are the previous matter and this is a connected matter.
CM 5 also
Yes, Your
is
Lordship.
taken. All have been served.
Yes, Your Lordship.
They've been served.
Yes, Your Lordship.
Not only 4. You're appealing for all of them, Dr. Muzika.
Yes, ma'am.
Union, Principal Commissioner, Assistant Commissioner, Superintendent. Yes. On the Dr. Muzika please come back for the 3 weeks time to file. Just accordingly and so on.
Obliged.
5.
Your Lordship, it's a connected matter. Connected matter.
5.
I was.
Same.
Yes, Your
Just
Lordship.
together with something.
Much obliged, Your Lordship.
Any mention?
So I beg to mention item number 63. Kindly may be taken up after 2 weeks.
No objection, Your Lordship.
63 is what?
63, Amit Saraf. I'm for respondent number 1.
You are for the petitioner?
Yes, Your Lordship.
Yes. Okay, yes, 2 weeks, yes.
Obliged, Lordship.
Much obliged.
Please, Your Lordship, I beg to mention item number 64. The conducting counsel is indisposed, Your Lordship.
He's indisposed?
Yes.
Who's the country council?
S.An., Miss S.An. Miss S.An.
No objection, Lordship.
Yes.
Much
2 weeks. Huh? Yes.
Yes, Your Lordship. I beg to mention item number 67, Lordship.
Number?
67. 67.
No objection, Your Lordship.
I pray for 2 weeks time, Lordship.
Yes. Miss Hassan,
Yes.
not, vacation not over yet.
Yes, Your Lordship. He is.
Yes, he's come back.
Much obliged.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 66, Your Lordship. I'm for the respondent number 4, 5, and 6, Your Lordship. I'm praying for 2 weeks time, Your Lordship. Highly
Okay.
obliged, Your Lordship.
Yes.
May I please, Your Lordship, I beg to make a mention of item number 62. I pray for 2 weeks time, Your Lordship, as the leading
No,
counsel
for
is indisposed.
For the petitioner?
I'm for respondent 6 and 7. I'm for respondent 6 and
You have no
7.
objection?
No objection.
Why to me, John was just.
Supplementary list item number 1.
Lordship, the conducting counsel is on deck. Can it come after
Who's
orders?
connecting council?
ASCTK.
You are appearing for? What's this matter?
Millards, here we had an objection because Millards, I am the landlord under whose title Millards the petitioners are claiming. Now I have not been added as a party in these proceedings, Millards. The directions by the Union Government and the Cantonment Board are all directed towards me. Now, I have not been added as a party.
Who are these people? They are the ones.
They were tenants.
Where they were? They were staying in this.
They were
hotel
tenants,
right now.
Millards. They were tenants. I am essentially a necessary party, Millards.
No, but then if they are affected by this whatever disaster, they won't have a place to stay. That means they're staying there only.
That is why, Millards, I say that I should have been made a party.
This guy has come. Yes, Mr. Vicky.
Just one objection I want to make.
Yes. Yes.
So, my lord, my only grievance here is that the Meghalaya Police, being a state agency, has been directed by the Cantonment Board, defense authorities, to do something without even consulting the SP or the officer in charge of the Southern Peace Station.
Let's see where that what have they been asked to do?
No, sir. Please come to page, section 1, page 61.
16. It's to Sultus Navigator. They are not made about it.
Yes.
This is a letter written by the Cantonment Board to the Lizzie, and it is still.
How do you get a copy of this?
Copy was given to the officer in charge, Cantonment Police Beat House. And what it says is that it is requested to take necessary steps to stop dumping of building materials in the presence of bungalow number 29 to stop.
Who's been dumping? The leaseholder has been dumping material?
No, that is also not.
This is the tenants, Millards. What happened is after that incident, Millards, without any intimation to anybody, Millards, suddenly we find, Millards, a lot of people coming in and dumping building material over there.
Like what? Like tin and cement and all?
Millards.
No, this is not the thing. It was a fire incident. We brought some triple to cover it up because we got some grain from the government after the arson. Then we will just to cook the meal. That was the only thing. But my question, my lord, is that how the police will intervene? They have got their own agency. If I am illegally occupying it, They have already initiated a process under the Public Premises Act.
You already facing those proceedings?
No notice, but they say it is there. Because here also my lord says.
Now the leaseholder is this Santosh Devi Goenka.
Yes.
And this okay.
Om Prakash Goenka, Kamal Goenka.
Okay.
And
now,
we are the
now
tenants.
they are subsisting lease with the.
Yes.
Lease expired.
That is under another litigation.
Also kindly see page 12.
But
it is expired
2018. Because the cantonment law says, my lord, there can maximum be 3 tenures of 30 years. So maximum 90 years. The last para is page 12.
Para 12?
Page 12,
the last para.
page 16.
Please note that a full term lease
Where is that?
of 90 years of bungalow number 4 was expired on 31/3/28.
Where reading from?
The last sentence.
I think, my lords, it would be page 16.
Not page 12 here.
Page 12 is.
No, page 16. Page 16.
my lords.
Last paragraph.
Oh.
Please note that the full term of lease 90 years is expired.
So how do you address situation to give them some relief?
My lords, may I pray your lordships kindly have this matter tomorrow. Let them just serve us a copy, my lords.
Because how will we left to face the elements? No, that is the thing.
Well, we do-
If whatever it is there, they entitle some shelter.
Ultimately, the expired lessee will be in a position to say whether they are actually tenant or not. Also.
Because my
But
lords,
this is
I
not
would
what
have
it is.
See,
This is not
what we concern, I think, if what I understand, the Siddiqui says that you only need shelter.
Yes, my lord. Temporary shelter that we want. We are not in a position to construct a house, my lord. Very poor people.
My lords, we should not allow, my lords, some third parties to, my lords, take advantage of the fire situation.
No third party will come on.
That, my lords, that, my lords, I will be in a position to, my lords, make a clear statement before my lords tomorrow. Let them just give us a copy, my lords. I'll verify and I'll make a statement before your lordships tomorrow.
Otherwise, how many families are affected?
43, my lord. Total 43, about 200.
These are those lease lands.
Bungalow number what?
29, my
It
lord.
is bungalow number 29.
Near
my lord.
Anjali Cinema, my lord.
Oh, immediately behind. Okay. I
Yes.
get it. So it's not so it's not, it's after Anjali Cinema.
It's beyond
Behind the, I think so.
Lot of shanties there.
Lords. Which is why, my lords, I humbly pray, my lords may have this matter tomorrow. At least I'll be able to say, my lords, who are the people who are there. It should not be some third parties come and take advantage of the situation. Is there anything that falls on my
staying
lords?
there without
Yes, my
just
lord.
being as squatters,
Yes, my lord.
squatting there only.
And we were paying the rent to the landlady.
Which landlady?
This, to whom this letter is addressed, Srimati Santoshi Devi Goenka.
My lords, this plot of land is, my lords, with the Goenka family. There are 3 shareholders of the property. All 3's names are there. So, my lords, which is why I say, my lords, I'll make a clear statement before your lordships. Who are the parties involved?
When the matter is moved by the National Council, or by when the matter is moved, the National Council, Mr. K. Paul, has apprised this court that the persons who have been, that he represents, the persons who have been named in a communication dated, in letter dated 20th Jan 2026 with regard to 20th January 2026 with regard to the matter in issue. So he prays that he may be given a corporate petition and be allowed to be implemented as necessary party stop. This court, on hearing the National Council, also on perusal of the said letter, hereby in its own motion, impledes the 3 of them and start with the 3 persons, that is Srimati Santosh Devi Goenka,
Om Prakash Goenka and Kamal Goenka.
Page 16 shall stand impleaded as respondents number
5, 6, 7.
5, 6 and 7 in the
6, 7, 8, sir.
6, 7, 8 in the main this petition. So copies to be supplied in the course of the day. Yes. Tomorrow. Yes.
Much obliged.
Instructions.
Item number 2.
It's very familiar, these names, right? Again and again.
My lord, here we had to challenge the SOP that has come in between, my lord.
My lord, what has happened?
What happened to those contempts already?
Contempt, my lord, is still pending. And what has happened, my lord? They have communicated a new letter, my lord. My lord, may kindly see.
Are the matters still pending?
Still pending, my lord.
The repression still pending.
Pending, my lord. They have
What happened now?
Now, my lord, may kindly come to page number 27, my lord.
27.
Now, they have sent a new letter, my lord. It says, please find enclosed herewith letter number so and so, dated so and so, received from the director.
27.
Yes, my lord.
It's an extension of term.
Right. Yes.
Yes.
It says, received from Director of Commerce and Industries regarding extension of the term of appointment to the post of Industrial Promotion Officer. So and so, my lord, under Regulation 3F of the Meghalaya Public Service Commissions, LF Regulation 9 for favor of your kind and information, my lord. My next page, my lord, 28.
Yes.
Now it says, while enclosing herewith copy of letter number so and so, kindly take immediate necessary actions and inform the undermentioned.
Out of service now.
Yes. Now, my lord, may see page number 29. It says, with reference to the subject cited above, I am directed to inform you that this department regrets its inability to approve extension of service of the following officers serving under 3F. In view of above, you are advised to follow standard operation procedure as per OM number so and so by filling up the post on regular basis. Now, and then they have enclosed the copy of the office memorandum, my lord, that is at page number 31. And thereafter, my lord, their service has not been extended. Now, my lord, in similar such circumstances, my lord, earlier, my lord has given direction to consider regularization of some of the employees. And that matter, my lord, thereafter, my lord, the state has filed an appeal against that order. And then in that appellate court, my lord.
Same petitioners?
No, different case, my lord. Similar, facts are little similar, my lord. And then, my lord, in the appeal, at the last paragraph, they have allowed, after condoning the delay of so many 700 plus days, if I am not wrong, 768 days, after condoning the delay, the court has allowed the state to go for advertising the post. And subsequently, the matter has travelled before the Supreme Court, and Honorable Supreme Court has passed an order saying that service of the petitioners shall not be disturbed. My lord, may kindly see the paragraph 22. The petitioner shall not be removed or in any manner therein position shall not be disturbed.
Order 30th.
Yes. Position shall not be disturbed and they shall continue to work. So similar circumstances, my lord. So I humbly pray.
How long you worked?
14 years, my lord. 14 years I have been continuing, and multiple cases, my lord. My lord is aware how much we are struggling. One of the petitioner in between has expired also. They have been continuing for so many years, and then all of a sudden,
government has rationalized all this entire, because they have to segregate between those people who are working and against vacant posts. We have to have special selection for these people who are working.
Yes,
they can work out something like that. Anyway, yes, who's applying for the state? Yes. Oh, yes, Mr. RP General.
Yes, my lord. Now, all these issues are pending before your lordship. Your lordship is considering the entire matter holistically, my lord.
Yes, so
yes, these matters.
Salary, my lord. Salary also.
The only thing is that you have to see, when we take up these matters for final disposal, some of them stand on all different footings. Though they all covered by your same SOP with regard that 25th September, correct? Which all agree
yes.
with. So that's the only thing. How you tackle it,
yes,
that's up to you. But then at least before we start, you should, there's different categories employees, those who are serving, who come by way of districts or by departments.
We have prepared
those are about 3F, or those who have just, yes.
My lord, for the last almost 1 year, prepared a chart, my lord. For the last almost 1 year, they have not received their salary also, and they are all having children and all, my lord, going to school. The state should also release their salary, pending salary, my lord.
My lord,
need some protection.
Issues are pending, my lord. So we'll consider all these matters together, my lord. Now they are not in service, slightly
my
different
lord,
position, my lord.
My lord, their service may be protected, my lord.
They are not in service, admittedly, my lord. Because Mr. Brendor, thank you's case is, my lord, I think they are connected to item 2 and 3 with 56 to 59, my lord.
Yes.
2 and 3?
My lord, I have filed a miss case as well, my lord.
2 and 3.
2 and 3 is connected with
2 and 3 and 56
Those are
to 59.
contempt cases, 2 contempt cases, my lord, and 2
and 3 today's hearing list.
This, yes, my lord, in daily list.
Yes, my lord.
56 to 59.
Daily list. 56 to 59, my lord.
Okay, yes.
My lord.
Or same petitioner.
Yes, my lord.
Same petitioner, my lord.
My lord, I have prayed for some interim relief, my lord. May kindly see the miss case.
Your lordship, consider all these matters together, my lord.
For the time being, my lord,
They are not in
their
service
interest
also.
has to be protected. It is not that, my lord, they are not in service. This order has just come, my lord.
They are not in service, my lord.
Yes. Take down third, Mr. Jensen Connor, counsel for the petitioner. Now issue notice. Mr. H. Abraham, Ms. Edlin Advocate General with Mr. H. Abraham's present. So on behalf of all the respondents, no further notice called for. The grievance with petitioner is directed against letter dated
15 December 2025.
Where's that? 15 December, 15 December.
Yes, my lord, that is at page number 29.
15 December, 30th.
2025.
That is against the letter dated 15 December 2025, whereby the extension of the term of appointment against the post of industrial promotion officer
Yes,
has not been approved. But it submitted that the petitioner and other similarly situated persons have been serving how many years?
14 years, my lord.
For over 14 years under Regulation 3F of the Meghalaya Public Service Commission, Regulation 1972. So it's also submitted that in connection with service, other petitions as also contempt applications are pending.
Yes.
Stop. He therefore prays that in the interim, the petitioners be given some protection so that they may continue in service.
Yes.
McFarlane Advocate General submitted that as the core issue in question is also subject matter of many other writ petitions which are pending before this court, wherein the office memorandum dated 25
September
9 2025 under challenge. This matter may also be clubbed together for consideration. He, however, also submits that the writ petitioners are no longer in service.
That is
he submits that the writ petitioners are no longer in service. Stop. On hearing the council parties, it is noted that it is undisputed.
These are the candidates who have failed, my lord, and despite your lordship's order.
That is
They
fell on 2 occasions. That is different.
Something wrong with your audio.
That is as regard to different advertisement. That is as regard to different advertisement floated by MPs. That is different.
Yes, and no. That the fact that the petitioners have been serving for
more than 14 years.
14 years is not disputed. However, with the passing of the office memorandum 25/9/2025, the respondents have No, this was not 25. The regularization or other further prospects are. What do you ask for the earlier repetition?
Earlier repetition, I prayed for regularization, and yes.
No problem. The prospect of regularization and other service benefits has come under a cloud. In this view, the matter is provided that until, if they're still in service, they'll still continue.
They are continuing, yes, madam.
Yeah, so that if the petitioners are still in service, shall continue for the orders. This is matter together with the badge matters.
My lord, only one thing has to be clear, my lord, because their extension was not approved. So otherwise, they were continuing their service.
Let them continue if they like.
Only that point may be clear.
Yes. If
Prisoner shall
shall continue services
3.
until further orders.
Obliged.
3.
Connected. Obliged.
To interconnected.
56, 59 also in daily list, my lord, connected matters. So.
That is a contempt.
My lord, connected in one way. Yeah, contempt matters.
There is no contempt, my lord.
There is, let it come up together, my lord.
There is no contempt.
Obliged. 4.
Please, Your Lordship. Your Lordship, this matter
Yes, what is this?
pertains to non-extension of contract, Your Lordship.
Extension of?
Contract. Your Lordship, here the petition.
How can you by representing ask extension contract?
Your Lordship, advertisement was floated, Your Lordship. Let me.
Advertisement
was floated for the post of claim manager, MHIS, state nodal agency, MHIS, in which I appeared and walk-in interview, and then I got selected, Your Lordship. The official appointment letter is in annexure 4, page 17, Your Lordship.
Lecture 7. Lecture 4.
Yes, Your Lordship, page 17.
Contractual basis for how long?
12 months, Your Lordship.
It's over now.
Your Lordship, in page
23.
In page 19, my contract was extended, Your Lordship.
For how long?
For four months, Your Lordship.
After that?
After that, even when the extension period got over, I still continue, Your Lordship, as a post of claim manager. Then in the meantime, Your Lordship, I also at the same time I hold a post of a teacher in Union Christian College, Your Lordship. It's a non-sanctioned post for minimal remuneration, Your Lordship, since 2007. But I've been managing both the work.
So same time you're working as in contract with this what's this? MHIS. Same time you're teaching also.
Yes, Your Lordship. So in the meantime, the principal of Union Christian College, Your Lordship, has applied for RTI, RTI application, asking about explanation from me, from the state nodal agency regarding my work, Your Lordship, in which I have, and then the agency has seek explanation from me, in which I have in annexure 7, page number 21, Your Lordship. I have given my explanation.
How can you have dual employment?
Pardon, Your Lordship.
How can you have dual employment?
Your Lordship, it's a contractual with minimal remuneration, Your Lordship. I've been maintaining both the work, Your Lordship, without any failure or without failure, Your Lordship. And then,
how is this petition maintainable at all? You are seeking the extension. How like? Yes.
Your Lordship, I'm not seeking
Even
extension. Your Lordship, in the meantime, Your Lordship, when they stopped my contract, Your Lordship, and they have given me a non-renewal of contract. No, but then, Your Lordship, after the while my contract was extended for the period for 4 months, Your Lordship, after that I was working. There was no official letter of me of my extension nor my stoppage of the contractual work, Your Lordship. And then they gave me a non-extension of contract letter that your contract has been stopped, and I filed an appeal, Your Lordship. But then the issue here is, Your Lordship, there's one person who I filed an appeal. There's no reply to my appeal. But then
I came. Suit then.
It came to my knowledge that another person.
You won for as per your term, but then as per your terms, it's over.
Your Lordship, but then with no proper reason, Your
Think
Lordship.
about it, otherwise, I don't think it's maintainable, yes.
Your Lordship, in the meantime, another person has been appointed without following the due process of appointment.
Your contract's over, they are liberty, they are the employer.
There is also arbitration clause in the order, appointment order. That is at page number 17.
It's already over.
Yes.
Arbitration clause will have no meaning.
In case of any dispute, clause is already.
You're only serving in one post.
Your Lordship, but then taking into consideration my periods of work, Your Lordship, without fail, I'm doing my duty diligently. I lead.
You're working as a computer operator.
Computer operator, clean manager, Your Lordship.
No, in UCC.
No, teaching.
Computer.
You're teaching.
Connected to computer only.
Connected to computer.
You take a call. You take heard MS Bisun operational. This court not inclined to admit the instant application on the ground maintainability and availability of altered relief under private law. Yes, learner comes to take instructions just after 3 days.
I oblige.
1 and 2.
Yes.
Obliged.
5.
We are before your lordships in this matter with some serious allegations against the state police. What had happened is, my lords, at page 24, my lords, would find an order of the Honorable Supreme Court dated 5/1/2026. And if I may just draw your lordship's attention. That's page 25, if my lords kindly have a look, my lords. Is granted to the petitioner to appear before the investigating officer on 29/1/2026 by 11 a.m., failing which this court shall consider dismissing the present special leave petition. So there was a direction, my lords, that was granted, issued to me, my lords, that I am required to appear before the RIML PS, my lords, in Meghalaya by the 29th, 11 a.m.
Yes.
So, my lords, I am traveling to Guwahati from Jaipur, my lords, at annexure 5, page 42, if my lords kindly have a look.
To appear before investigating
My
officer.
lords. We had also given an intimation, my lords, earlier. Unfortunately, that's not part of the record. Annexure 5, page 42 is my boarding pass. Now, once I land in Guwahati, my lords, a CISF personnel, my lords, detains me on the tarmac of the airport. And, my lords, I have the police from Nongpo, they come and take my custody from, my lords, the Guwahati airport. Now, the arrest memo, my lords, which has been produced by them before the court, if my lords kindly have a look at it. Annexure 6, page 43 onwards, my lords. The relevant page will be page 44.
Yes.
At 16, my lords. Serial number 16. The arrested person, after being informed of the grounds of his arrest and legal rights, was duly taken into custody at Khanapara PS on 27/1/2026 at 8 p.m. I was detained, my lords, and my custody was actually taken at 4:30. Now, my lords, I am before your lordships with a twofold prayer. The second part of my grievance is, my lords, is that when my counsel is trying to go and meet me in custody, even, my lords, my counsel is not permitted to meet me. To that extent, my lords, we were forced to issue a letter to the IO, which again they refused to receive. My lords would find it at page 49, annexure 9. If my lords have page 49, my lords. My lords, the specific instances, this is written by the council, my lords, with reference to the subject cited above. The undersigned would like to bring to your notice that so-and-so was arrested on so-and-so in connection with so-and-so. In this connection, it is stated that on 29/1/2026 at around 8 p.m. when the undersigned went to meet Shri so-and-so to take signatures of the petition to be filed before the appropriate legal forum, the undersigned was denied to meet him in person, as a result of which the undersigned had to return without getting to meet him and obtain signatures. That on 31/1 so-and-so, again, my lords, went to meet, denied. Thereafter, my lords, after making a lot of requests, finally we were permitted to meet this person for 5 minutes.
Yes.
Well, it's the other issue. What I'm instructed is, my lords, as your lordships would be aware, that when a person is in custody, my lords, all documentation signed by him has to be countersigned by the police. that it is signed in their presence. They refuse to do it. I am before your lordships under only with the
story behind it. Why for one single person there's so much? How many petitions or how many petitions have you filed?
Where, Milits?
I mean, in this court, any other pending?
Milits, there's one quashing matter pending, Milits.
Writ petition, no. You had come earlier for writ petition, correct?
Milits, I had come before your lordships to find out the exact number of writ petition criminal cases that your lordships disposed it of. Therefore, Milits, now I'm protected. Otherwise, what was happening every time, Milits? A new case. Every time a new case. Your lordships will kindly appreciate, I come to appear in RIML PS, Milits. In the Guwahati airport, they arrest me from Khanapara PA. Yes. And that, my lords, if my lords kindly see the first remand order, things become very clear. If my lords kindly have a look at page 46 and Annexure 7.
Yes.
CR put up today and I am endorsed with the police papers of bail matters. Accused so-and-so is produced before this court on being arrested in connection with this case, on being asked by the accused person that he is not well as he is diabetic patient and has back pain. On being asked whether the medication is provided to him, he has received medication. Accused submits that he has defense counsel. Seen forwarding report dated 28/1/2026 where the IO has narrated the brief facts of the case, briefly summary and findings during investigation and progress of investigation, and has prayed that the accused may be remanded to 10 days police custody for the purpose of recovery of the vehicle bearing registration number so-and-so which is in his possession as admitted by him in front of the lawyer at the time of examination, and also recovery of all documents, ATM cards, bank passbooks, licenses, etc. belonging to so-and-so bonded warehouse for the interest of investigation. Seen the memorandum of arrest dated 27/1/2026 at 8 p.m. As per the arrest memo, seen that Shri Kaushalya Gaur, wife of the accused, has been informed over phone of the arrest. Seen checklist where the IO in his justification of arrest stated that the further ascertain the facts and circumstances of the case, recovery of stolen vehicles and recovery of forged documents. Seen intimation of the rights of the arrest person, intimation of so-and-so, so-and-so. Seen medical report where the accused is opined to have no external body injury. He is known for hypertension, not under the influence of alcohol. He is under medication of Dr. so-and-so for hypertension and back pain. He is fit to be kept in custody with hyperintensive medication. Seen medical report dated so-and-so where the accused is the opinion of no injury, no so-and-so, so-and-so, so-and-so. I'll skip.
Now, what is this? He has continuously violated bail condition?
Well, it's that matter is under consideration before my lords. Well, it's another matter, another bench is hearing that matter.
Yes. Yes.
Well, it's here, my lords.
Only asking to meet the constitution.
I have two prayers, my lords. One, that my lords, my lawyers should have unrestricted access to me.
That's unrestricted, it should be monitored access.
Yes.
Monitored, definitely, my lords. He's in custody. So, if a lawyer, my lords, your lordships are aware, D.K. Basu, my lords, the Honorable Supreme Court has categorically laid down. Right to legal representation is a fundamental right.
Of course. No, there's no quarrel with that.
My lords, we are not.
Why? But is it a fact? They've been denied counsel.
My lord, I'll have to seek instructions, my lord, because right now the case diary pertaining to Khanapara PS is before court number 3, my lord. There's a revision pending before this.
Not the case diary. Those are miscellaneous
case records. I'm sorry, the case records are there, my lord.
See, what this court wants to know is whether he was really denied. The lawyers really denied access to. I mean, not allowed to meet the petitioner. That's the only thing. That cannot be.
My lord, it's fixed today before the trial court. Also, it's fixed for today for production, my lord.
Those are different issues, my lords. I am not with those prayers before my lords. The other prayer, my lords, which I am pressing before my lords is, my lords, that the CCTV footage from the 27th of January, my lords, from the Guwahati airport be, my lords, preserved and produced before your lordships. Because, my lords, your lordships will kindly appreciate.
See, the thing is that when they arrest another state, you have to inform the magistrate of that area that they are
lordships.
That's all.
That's not been done.
In this case, if the CISF has must acted on some orders.
They have not, my lords. Otherwise, why would I be shown as arrested in Khanapara PS? Which is why I pointed out to your lordships, my lords, that if the police are saying I'm detained in Khanapara PS, my lords, your lordships will first ascertain whether I was at all detained in Guwahati airport or no. But CISF, my lords, otherwise also, my lords, was not in a position to detain me. It would have, the Assam police would have been required.
Distance? Is it within 30 kilometers?
No, it is not.
Of the place of.
It is not, my lords.
Place of the.
My lords, from Khanapara, from the place of person, the magistrate having jurisdiction, my lords, the magistrate having jurisdiction would be Nongpo. Khanapara to Nongpo would be about 45 kilometers.
But more importantly is whether your access to your legal counsel, that's all.
Well, it's only those two limited prayers, my lords. One, legal counsel, my lords, and the second, my lords, the...
Mr. Careful.
Because this is very serious, my lords, but can you appreciate it?
Senior counsel for the petitioner, assisted by so and so stuff. Now this application, this writ application has been filed, sealing the alleged wrongful arrest and the non-allowance of the right to consult a legal representative by the petitioner stuff. Have been submitted by the senior counsel that the writ petitioner was arrested on 27/01/2026 from Guwahati Airport in connection with
this is Khanapara PS case number, my lords,
in connection with
25/7 of 2024.
PS case number
25/7 of 2024, my lords.
Of so and so. Thomna. Stop. It is further submitted that after his arrest, he has not been allowed. The defense counsel, his lawyer, has not been allowed to meet him. For which, where's the letter?
My lords, that's at page 49, my lords.
For which the officer in charge, for which a letter has been, for which a complaint has been filed before the officer in charge, Khanapara Police Station.
With copies to the DG and SP both, my lords.
Opposition copies to the DGP stating this fact. I therefore praise at this stage that the writ petition, the defense counsels be allowed to meet the accused person who is in custody. He's in police custody? Or
He's in police custody.
Presently in police custody.
Being produced today, Lordship.
Eh?
Being produced today before the
Yes,
trial.
MS NG Shilla, Leonard Senior Court Advocate, appearing for the state respondents, submitted that with regard to the submissions or allegations made, he will out to obtain instructions. Further submits that as per the order dated.
Order dated 28/1, my lord.
28/1, the accused is produced today, and as such there should be no impediment for the defense counsel to consult, for the accused to consult the defense counsel. So be it as it may, as far be it as it may, it is expected that any person accused in custody be denied access to legal counsel. As such, if the allegations are correct, it is directed that the officer in charge Khanapara Police Station should facilitate visitation by the defense counsel of the writ petitioner, which shall be duly monitored by the in the station itself. Stop. Just after 1 week for instructions. Yes. The other matter we'll take up later regarding your wrongful arrest.
Yes. That's okay. Now he's passed on to it.
You 1, 2, 3. Mr. Devnath, present on behalf of respondent 1, 2, 3.
Well, it's only thing that these, I don't know how long these records are kept, these CCTV footages are kept. Well, that's, the footage should at least be preserved. Well, it should not be a case like subsequently when your lordships take up the matter, we inform that the...
That will take up, let's see, after 1 week, let them...
Well,
my lord, I think notice will have to go to respondent number 8. He's been named in person, my lord.
Who number 8?
He's the person who came and took my custody, my lords, from Guwahati Airport.
Okay. Mr. Devnath, present 1, 2, 3. Some notice to...
No, he's 8 is the IO.
Yeah, but you name him in person.
Who's he?
He's the IO of the case, my lords.
But you name him in person, so I can't.
Not necessary. I was under the impression is that other person.
Much obliged, lordship.
Item number 6. This is that St. Peter's pollution.
So on 2/2026, order specifically passed, which is quoted here and below. Stop. Prohibitions order. Next one. Today also there is no representation of the petitioner. Therefore, the petition stands dismissed from prosecution.
Okay.
Yes.
Legal is item number 1.
What is this? Where's the counsel?
Your Lordship, she was supposed to join.
He or she?
She, as Lamba.
Just now it's the different person.
Yes, Your Honor, I saw that.
Argue the matter. You have the file with you. What's the matter about?
Your Lordship, I do not want to mislead the court. I am not aware of the fact of the case.
Yes. What's your name?
J. Noput.
J?
J. Noput.
You know. This is the person.
Your Lordship, I do not recognize her face.
We can't carry on like this. Yes, who are you? Switch on your audio. Yes. Well, she's the one, I guess.
Please, Your Lordship. Please, Your Lordship, this is that case where we had earlier approached Rajasthan High Court, and then after taking liberty, we had approached this Honorable Court. Please, Your Lordship, the issue was with regard to the liberty which was granted.
Yes.
Please, if Your Lordship will see the order doesn't say liberty has been granted, but my application stands allowed, and that application has specifically sought liberty to approach Your Lordships.
Where's the Rajasthan High Court order?
Is it
Yes. Please, Your Lordship, just give me a moment.
no liberty, sir?
Yes. Yes.
Please, Your Lordship would have Please, Your Lordship would have page 81.
Yes. Yes, there's no liberty given here. 80/2025.
And Your Lordship would have that application. Please, Your Lordship would have my application at page 78. Your Lordship would find my prayer at page 79. It is therefore humbly prayed by allowing this application, the present writ petition may kindly be directed to be transferred to Honorable Meghalaya High Court as the pleadings have been completed in the matter, or in the alternative, permission may kindly be granted to the petitioner to withdraw the present petition with liberty to file a fresh writ petition before the Honorable.
Yeah, Dr. Mozika. Although it does not, the order does speak so, but then it says upstate above, applications allowed.
And my humble submission, the order has to be read, my lord, not the application.
No, see, in the order itself, for the reason same application, the same is allowed. File affidavit will take it off consideration.
And that is only one aspect of the matter, my lord. The main issue, my lord, even if we ignore this aspect, my lord, the recruitment rule says that he has to be, lots of kindly come to page 38.
There's a lot of disturbance coming from your end, Ms. Lamba.
Please, Your Lordship.
Yes,
Please,
sir.
There's a lot of audio disturbance.
Number two, electrical engineer, can he be electrician, my lord? The electrical engineer and electrician are two different things.
He's electrician or electrical engineer?
Electrician, his degree is of electrician.
You file affidavit then. He has heard MSS Lamba so and so. The writ petition is admitted for consideration. Stop. Dr. Ambassador, please phones allowed 2 weeks time to file affidavit. 3 weeks time, yes. Yes.
A mystery is
Great for your lordship.
architect, my lord.
Item number 2.
Some mysteries are better than architects. Yes. Where's Mr. S. Deb?
Your Lordship, in this matter, we're supposed to seek instruction regarding the age, so I humbly pray another 2 weeks, Your Lordship.
What's the matter about?
This is the case, Your Lordship.
Oh yes, that appeal has come and come back.
Now, she has been declared by an order of the gate overaged. She is not eligible to be. Now she is questioning a third party's appointment. Well, is the service matter maintainable, Your Lordship? That's what we are saying right from the beginning.
Mr. Deb is out of station.
Tactical adjournment.
2 weeks to seek instruction.
Okay, after 1 week to allow Richard to obtain final instruction. We'll dispose it of. I remember this matter.
Item number 3.
This is my lords, the election petition. We were supposed to, my lords, file a compilation. We are, my lords, filing it in the course of the day, my lords. The compilation.
But Lordship, my interruption is that my lord friend took several days. You could have filed little early so that we can also see the things. But actually, unnecessarily, my lord.
Work it out among yourselves, you know. The courts are the mercy of lawyers, anyway. Yes, Mr. A.S. Pandey, have you put an application? Where's the application, Mr. Pandey?
We file an application, my lords.
Yes. Mr. Path Order City. Yes.
Item number 4.
The date when you want to get 2 weeks.
After that, my lord, order can be reserved, my lord, because unnecessarily my friend is.
Let them file it first. Yes. Otherwise, you make up your mind whether to pursue it at all. Now, 28 is just round the corner. Yes. Yes.
Item number 4.
One of these matters relate to that the issuance of trading license, and as per the last order, representation by respondent number 5, that is Darbar of Majai, is awaited. Are you appearing?
Where's number 5? You appear number 5?
Yes, Your Lordship.
Your name?
R.S. Malayang, Your Lordship.
R.S. Malayang, yes.
However, Your Lordship, no proper notice was served, Your Lordship. I'm just appearing voluntarily.
Doesn't matter, yes, very good. At least you appeared.
Yes.
So, R.S. Malayang has entered appearance in behalf of number 5. As such, notice complete all respondents.
No, my lord, acting CM also has been appointed in place of the deceased CM.
Oh, that's also in controversy.
Yes.
But can he take the action? That means him.
I guess, my lord, he can. The acting CM has got nothing to do here. What we are saying is that it's the Sardar who should issue the NOC.
Yes, Sardar Majai.
Yes, more importantly.
Right. You'll be Darbar Sardar and Darbar Majai.
Yes.
You have copies of the application?
I have not received any copies.
Mr. D, you kindly
I'll
give
supply him.
Ms. R.S. Malayang has an appearance in behalf of number 5. And those complete respondents. Mr. S. D. is appeared to serve copies of the petition on the spot number 5. Within?
Today you will give him a copy.
Yes. Just after?
2 weeks. After 2 weeks. We'll xerox it and give it to him today. So the entire list will go.
47.
Keep this.
Yes, CRPF recruitment matter मेरा खाना पड़ा.
Yes.
Americo.
Yes.
Lordship is supposed to file a affidavit, Lordship, in this case.
Affidavit to what?
Why? Supposed to file an objection, Your Lordship, regarding the jurisdiction, Your Lordship.
You file objection. You are supposed to file objection.
Lordship, the respondent, Your Lordship.
Is that correct, Dr. Mazika?
There is no such direction, my lord.
No.
In fact, the
Argue
matter
with-
was heard on last occasion, my lord, before today business.
Yes.
High Court of previous order.
Lordship, as per the order 1710/25, Your Lordship, supposed to allow. They have not filed the affidavit, Your Lordship. 1710.
You file a short affidavit then.
But after 1710, there are several orders, my lord. The matter was, in fact, Mr. Paul appeared. Mr. Paul appeared on one day, and the matter was argued that it took some time to satisfy this honorable court, my lord. I can file this, no problem, my lord. But that was not the case, my lord.
They're to their detriment only.
My lord.
We are resisting the.
Yes, ma'am.
Mr. Appealing for the counsel of petition. M. Karanlang or Snaitang?
Lordship Snaitang.
Snaitang. It was a B. Snaitang, the commissioner has submitted that the affidavit yet to be filed by the respondents. Dr. Mbozika has submitted that though this matter proceeded beyond that, however, maybe without 2 weeks' time to file. 3 weeks. 3 weeks is okay.
48.
Please, Your Lordship, I require 2 weeks time to file the rejoinder, my lord.
How many times you've taken?
No, I think 2-3 times.
2-3 times, then no more. How many times?
Lordship,
So we'll give you one more time. Yes.
Lordship.
As said, last watch day of 2 weeks granted for rejoinder. Expected on the next day, the journey should be on board. Yes.
Apply, Your Lordship.
49.
49.
I'm praying for some more time, my lord.
Who's the paying
2
for the
weeks' time,
petitioner?
my lord. Mr. B. Dev was given. Her motion.
Her motion. None appears for the petitioner. Respondent prays on the Lord for the 2 weeks' time to file affidavit. Yes.
50.
Lordship, we pray for some more time, Lordship, to file an affidavit.
When was this matter
1 and
filed?
2, Your Lordship, regarding the selection of these
Veterinary doctor.
veterinary doctors. The private respondents have appeared, Your Lordship, there also, I think.
No one's filed affidavits yet.
No, Your Lordship.
MPSC, you are for the
Private respondent.
Those are the successful candidates, private respondents. We are for the state 1 and 2, and 3 is the MPSC. Your
When will you
Lordship.
file it?
We'll file it in 2 weeks' time, Your Lordship.
2 weeks' time. Similarly, 2 weeks' time.
More or less ready, Your Lordship. Our affidavit is more or less
Yes,
ready.
sir.
Your Lordship.
MSD Yangi B, EAG for respondents 1 and 2. MSBF Karanlang for 3, and MS CB Savian for 3 or 4 to 54. Refunded for the 3 weeks' time to file affidavit. Yes.
Oblige, Your Lordship.
51.
Matter is this matter.
Yes.
This matter is listed for instruction, my lord. If the lordship will kindly see the lordship's order of last order of 8 December, because there are 3 petitions, 3 orders passed by the speaker in respect of 3 MLAs, my lord. Now, my friend has, and I have raised the objection as to maintainability of the joint writ petition, my lord.
Lordship,
so they have sought
Yes, are you appearing? Are you appearing for the petitioner? For the petitioner?
Yes, my lords.
You are,
appearing for the
Mr.
petitioner. My name is Advocate Surya Kiran. I'm appearing for the petitioner, Mr. Manuel Baduar.
Okay, yes. What is your submission?
Lordship, my submission is very simple. This order, so my lordship, firstly, I would say that there were 4 MLAs who were disqualified from the political party because they suddenly resigned illegally. That is the question of law which is concerning this particular writ petition, that whether this entire shifting from one political party to other, does it fall within the doctrine of merger of under the 10th part 10 of the schedule, 10th schedule of the constitution? Is it falling within that, or is it outside of it? That's the main question. All of these 4 orders that we are assailing are concerning the disqualification petitions that I had preferred against these 4 member of Legislative Assembly.
But Mr. Kiran, you had preferred individual petitions, I suppose, before the Speaker.
Yes, individual, but they were all on the same facts, my lords.
Doesn't matter.
Involving the same question of
Doesn't
law.
matter. But
And
if
my
they are
lords,
separate petitions, yes.
My lords, I am
separate orders also.
I am representing that political party under which this entire merger has happened between 2 legislative parties. This is involving common question of law, my lords. And my lords, I have also invoked the extraordinary jurisdiction of this honorable court. That's my main issue here, because since the last 2 years, around 2 years, we have been pursuing this litigation. This is concerning a constitutional doctrine. This is concerning democracy. This is
We understand. Yes, very well and good. Well and good concerns the constitutional doctrine, but whether the procedure is right, that's the only thing. Have you paid court fees?
My lord, you also will see the order at page 44, my lord. These are independent orders passed in respect of each of the MLA, my lord.
Yes.
And giving rise to independent cause of action. So therefore, in this form, my lord, this writ is not maintainable. I can argue any date can be fixed on maintainability on this score only, on this point only.
If you choose, to pursue, yes, Mr. Kiran, if you choose to pursue the writ petition as it is, they will have a hearing. Yes.
Please, my lordship.
Yes. Mr. Surya Kiran, right?
Yes, my lords.
Yes. Learned Counsel, on behalf of the writ petitioner, has submitted that they seek to maintain a single petition against 4 individual orders, inasmuch as the same involves a common section of law. Learned Advocate General, appearing for the respondents, says that the matter fixed for number 1, he fixed for hearing on the preliminary issue of maintainability. Prayers allowed. When do you want the hearing on?
2 weeks.
Yes, sir.
After 2 weeks, 3 weeks, only have.
Yes.
Much obliged.
52.
Great for me.
Please, Your Lordship. Your Lordship, I'm praying for some time to file our affidavit.
What's the matter about?
My lord, I am asking for, my lord, certified copy plot of land, my lord, which I lost, my lord. Initially, my lord, they asked for, my lord, submitting undertaking, which submitted, my lord.
Okay.
Thereafter, my lord, they directed us to submit, my lord, police report. That will also submit. Now, my lord,
when will you file affidavit?
In 2 weeks' time, Your Lordship.
Yes, MSLG for GA. 3 years that we allowed. 2 weeks for the time to file affidavit. Yes, please allowed. Yes.
Can a date may be fixed, my lord?
You take a date in the court.
Yes.
Obliged, Your Lordship.
53.
Please, Your Lordship. Lordship, we're seeking further time, my lord. We are yet to receive instructions.
Yes. Yes, MSG sir. Please sponsor both the 2 weeks and file affidavit. This is the reference.
Much obliged, Lordship.
What of one long? At least the after. Only.
54.
Only. What's the matter about?
This is a matter where my friend, client, has joined a political party when he was a staff of district officer. And he has admitted in his reply.
Are you only a driver for the MLA?
Yes.
It's not a regular driver. I was just
went and dropped my uncle only for once.
No.
That was there. And then there's so many grounds I have challenged. I have another main thing is that there is no specific prescribed for punishment as per the rule which they have mentioned, because it speaks about integrity and devotion to the duty and maintaining the political neutrality. That is under which the rule which they have terminated does not prescribe any specific punishment for, yes, like this Meghalaya Service Conduct Rule 19 they have quoted. Then they also stated that they will follow this rule only, but in this particular rule there is no specific prescribed for punishment. For minor punishment, major punishment, there is no penalty.
He was terminated.
I was terminated.
But here, the case is this: he is a temporary employment. He was holding a post of temporary post, my lord, and he can be terminated at any point of time without giving any reason.
Remember, ID card issued in your name.
Yes, ID card was issued in his name.
That ID card also I'm denied, because you had issued without my knowledge, because I have not
without knowledge. Everything is without his knowledge, my lord.
What is issued in your name?
And whatever may be, lordship, the main argument is lordship that the procedure, when they have drawn the disciplinary proceeding against me, there is no officer has been assigned to me to assist as per the rule, your lordship.
Yes. Where's this? Where's ID card? The complaint produced ID card of Meghalaya Pradesh Congress Committee.
ID card is not given.
See, you annexed it, your ID card.
It's not here, my lord. I have not.
You produced it before the authority.
Yeah, my lord. It is written here, my lord.
See, page 29.
29.
Paragraph in the middle, paragraph 1 again.
My lord.
On the different charge.
See? Carry out the year done the same without involved in any political party. That he had done the same. Here is mentioned. I have denied it. To deny, I have mentioned there the charges where it says that he had replied that he had done the same without being involved.
See number 1 after that. 1, 2. Forget the first charge. Second one. Second part.
Just this.
Where your names given.
Complaining.
Done.
We have given the ID card number.
Where's ID card? Let's see.
That ID card actually.
They have not enclosed, my lord.
No, actually, it's not with me.
He did it from you also.
They don't. The petitioner did not supply, so I could not enclose it.
So what do you plan to do then?
See, lordship, there are so many grounds which I have challenged, because they have drawn the disciplinary proceeding, because in that disciplinary proceeding,
you don't deny. You don't deny that you were involved in political activities, either driving or campaigning. That doesn't make a difference. And number one, couple of facts that in the inquiry, one proceeding itself, you have produced and they have been produced. Then what remains?
Lordship, they have not even stated.
Employee.
They have not stated my during the inquiry. They have not stated my statement. They have not recorded my statement. The statement of the delinquent has not been recorded, and I am supposed to be assigned with one particular officer to assist the inquiry officer. That was not there, and all the documents regarding the list of witnesses.
Have you made a petition regarding before them? The PAN proceedings, say, be allowed defense.
Your lordship, it is the
give the materials. I want to examine the complainant.
That application, lordship, that is not mandatory, because the moment they have initiated the departmental proceeding, it is their duty to.
And remember, you're not entitled in the department proceeding. Also, they're a temporary employee.
Temporary employee.
But they
fire and fire.
No, not temporary, not temporary employee, lordship.
My lord, he has not even read his appointment letter. My lord is.
See, read P17, your own annexure. The appointment is purely temporary, without assigning the reason.
No, this appointment, appointment letter, they have been giving to not only to me, but to even to the permanent employee. They have been exercising this type of letter.
See, what kind of
appointment
submission is that, Mrs. Tangma?
Lordship.
Is that kind of submission for council to make? Your permanent is temporary and it's the same one given to permanent employees. When we dismiss the case, you can't make these kind of layman submissions. You admitted, even then they should have just fired you. What do you want to do? You represent for the authorities. You withdraw the petition, otherwise
Let him make a representation.
Yes. Mr. P.T. Sama says that he will have to withdraw the petition with deputy to file representation with authorities for reconsideration of his temporary of his termination from temporary post of foreign danger.
55.
What's first lawsuit?
May it please your lordship. Lordship, I pray for some more time to file an affidavit.
What's the matter about?
Restoration.
Restoration, your lordship.
40, 22. How much? 3 weeks time?
Yes, your lordship.
MS General Vice so and so please one allowed further 3 weeks time for affidavit.
Highly obliged.
Hearing. Supplementary list 7.
Petition. May it please your lordships. No, my lord, in the course of submission, my learned senior friend Mr. Shulai, now he has pointed out that those who qualified for promotion after the cut-off date, that is 5th March 2010, they are governed, it is specifically mentioned, they are governed by the CS regulation of 2012. There is no dispute in the bar. I'll take my lord again to that provision, my lord. That is at page 80. Page 80 of my writ petition. That is mentioned in CAS regulation notified on 8th November 2012. Page 80, my lord. My lord. Now this is, my lord, in the CAS regulation notified on 8th November 2012. Lordship, on the top, 1.3 proviso. Provided that even any candidate become eligible for promotion under CAS in terms of the regulation on or after 5th March 2010, the promotion of such candidate shall be governed by the provision of this regulation. We are not disputing it. We are, my lord. We are covered by, my lord, CAS. Admittedly, my lord, my promotion became due. It is not disputed, my lord. I mean, mentioned in the impugn order in the year 2011. After, my lord, 2010 rule was notified.
Yes.
So I am not disputing it. But this should not be, perhaps my learned friend is projecting that if your case become due after the cut-off date, then PhD is mandatory. I'll take my lord to that paragraph 3.8. Now here it says, lordship will take note, become eligible for promotion. That means you come within the zone of promotion after the cut-off date. Now what that paragraph 3.1 say, my lord?
Provided that when any candidate becomes eligible for promotion under CAS on or after.
On or after.
The promotion shall be governed by the principle of these regulations.
2002. Obviously, my lord. I am governed by this. Now, my lord, if I can take your lordship, my lord, the various stages of promotion in the same regulation it is.
Only that part, Mr. Sen, you see, the thing is, you will not require PhD.
Yes.
If you are joined before 2000.
My lord.
Before 2000, you will not require PhD.
Not required.
Yes.
That's.
And now they're saying that fine, you don't require PhD, but the fact is that your promotion became due after 5th March 2010, earliest came out.
Exactly.
And so, since you have come after, became due after 5th March, that's in 2011, then that will be a necessary requirement.
I know.
That is
That's what I'm trying to.
That's the only thing you have to clarify.
Yes, yes. I
enlighten the court.
Exactly. So he is saying the zone of consideration. Qualified means you come within the zone of being eligible to be considered after the cutoff date. Then perhaps you want to say then PhD comes. Now what 3.8 say, my lord, at page 82? There is some typographical error, my lord. A corrigendum subsequently should I take my lord to that also. 82.
Yes. However, those joining the service after March and should have also on PhD edition above who have joined service. Now you're trying that distinction.
Join the service.
Join service and due for promotion, two different things.
Two different, absolutely.
That is what the point you're trying to make.
Well, joint service means what, your lordship? You enter into the service. A service comprised of different cadres. There is the initial cadres, then by promotion you move to the next cadre, further, my lord, you reach the hierarchy, my top level, at the top of the hierarchy, your lordship. That is, my lord, clear, very clear.
So your argument is that
join the service.
Zone of consideration is different.
Exactly.
And
joining
service different.
Joining service different. And my lord.
So if you come zone of consideration,
entry level,
it becomes due 2010, you'll become the regulation.
Exactly.
Correct.
Exactly.
But the requirement PhD will not apply to you because you had joined earlier.
Already. And another thing your lordship will see on the top. This is under
note of that.
This is under the heading, my lord. Paragraph 3, page 82.
One second,
my lord.
Yes.
Yes, my lord. Now, lordship, kindly, my lord, 82 on the top, paragraph 3. My lord, this is under a heading. That also matters. Lordship, kindly look into the heading.
Yes.
Stages of promotion under CAS scheme for, they have mentioned very categorically, incumbent and newly appointed lecturer.
Where reading from, sorry?
My lord, on the top, page 82, paragraph 3. Paragraph 3. Same, 8.3, 3.8 is under paragraph 3.
See, stages of promotion under career advancement scheme of incumbent and newly appointed lecturers. Okay?
Exactly. This is speaking about those who are already in place and those who are yet to enter. So, however, my lord, that is very clear and categorical, my lord. Entering the service for the purpose of service seniority, not promotion. And this will be further clear, my lord. My lord, there are some typographical error, as I said, my lord, in this paragraph 3. Subsequently, when they issued the clarificatory regulation of 2016, my lord, they have reissued the same regulation, my lord, with typographical corrections, my lord. If I can take kindly, my lord, to that. That is at page 122. My lord. 3.8, except, my lord, the payment, all those things have been corrected. Ditto, the language is same. However, though joining service, fifth one shall also have PhD in addition. Now, your lordship, my lord, this is, my lord, stage 4. 9,000 is stage 4.
Yes.
9,000 is, my lord, stage 4. Now, my lord, by this regulation CAS, my lord, a lecturer also has a scope to move to stage 5. Now, stage 5 is pointed out, my lord, 3.9, where, my lord, irrespective of date of entry, PhD is mandatory. Lordship, if I can read out 3.9.
Yes.
Head of the department / lecturer selection grade, completing 3 years of service in AGP of rupees 9,000. Possessing PhD degree in relevant discipline shall be eligible and subject to other conditions of academic performance and ACD shall be placed in such and such AGP of 10,000 stage 5. Here, my lord, they have made PhD compulsory irrespective of your date of entry. It is compulsory for incumbent as well as freshly appointed. My lord, there should not be any confusion. 3.8 and 3.9, my lord. No, 3.9, I am not eligible.
Yes, so you'll go up to 9,000 only.
I go maximum 9, in that sense. But I cannot go to 3.9. To 3.9, otherwise, my lord, the same language would have been used in 3.8. So my humble submission, your lordships, this creates a substantial right in my favor. 3.8, a substantial right. Since I am an incumbent professor, I do not require PhD. A substantial right, and my lord is fully aware, a substantial right, even by a subsequent amendment, cannot be taken away. A subsequent amendment will have a prospective effect, not a retrospective effect. And here, admittedly, my lord, there is no amendment. What the AICT and the state government is saying, my lord, they are relying only on the clarification of 2016 made at point 10 and 43. Now, point 10, your lordships, very categorically say they are clarifying the entry level qualification as laid down in 2010. And further they added, for their movement to selection grade, PhD is necessary. Obviously, my lord, this clarification is meaning those entering the service after 5th March 2010. Now, my lord, interestingly, your lordships, 2016, as I have, my lord, submitted, came up for consideration before the apex court, before a 3 judges bench, my lord. 2020, I have submitted that decision.
Yes, that's.
There they said, my lord, this is not amended, it has not amended. Now, to deprive me, my lord, 3.8 request to be amended. No, it has never been amended. Supreme Court has clarified, my lord, this is not a mandatory. Further, Supreme Court has held, my lord, the language of the Supreme Court is this, your lordships. Clarification.
Just the judgment.
My lord. Page 90 of my compilation. Further, my lord, in this judgment also, your lordships, what the Supreme Court has held, that clarification cannot be used surreptitiously as a tool for amendment. An amendment has to be provided by an appropriate law, my lord, categorically amending that provisions. If I can take, my lord.
What paragraph?
My lord, I am just coming, your lordship. If I can, my lord, start, my lord, reading from paragraph 25, my lord, these are relevant. Page 100. Page 100, my lord. The present case is when, where except the title, nothing contained therein indicates that 2016 AICT notification has clarificatory in nature. The same notification is framed in question-answer style and merely relates to what has already been made explicit in 2010 AICT regulation. There seems to be no intent to alter the position of law, but instead only to simplify what AICT had resolved through its original regulations. The 2016 AICT notification is in response to doubts put forth to AICT by public. This is evident from the stand put forth by the AICT and reply as well as during the course of it, namely that there is no retrospective alteration in the qualification prescribed for the post of minister. Even if
27 is clear.
Yes. Even if 2016 AICT notification was clarificatory, it must be demonstrated that there was an ambiguity in the criteria of appointment to the post, which needs to be remedied. Clarificatory notification are distinct from a mandatory notification, and the former ought not to be a, my lord will take note, former ought not to be a surreptitious tool of achieving the ends of the latter. That cannot be used as an amendment. That exactly what the, my lord, respondents are trying to do. That clarification, they're taking shelter of this clarification and they said, whatever, my lord, the benefit I have been given 3.1 stand erased. That's wrong. If there exists no ambiguity, there arises no question of making use of clarificatory notification. Hence, in the absence of any omission in 2016 AICT notification, despite being generally must be held to have reiterated the existing position of law. Now, my lord, the same, my lord, same judgment, your lordship. I am not troubling your lordship with too many judgments. Same judgment also with retrospective effect. But here, my lord, since there is no amendment, the question of retrospectivity will not come. Here it is saying, my lord, even if it is there is an amendment, that cannot be retrospective. My promotion, assuming, my lord, without admitting, clarificatory notification of 2016 is an amendment. My promotion became be due 11. Now in 2016, you could not have extinguished my right, which had arisen, my lord, in 2011.
So, no two interpretations are possible.
No possible, my lord. So, my lord, here it is clear and categorical, and their only submission
So
is.
your basic case is this:
Lordship.
these regulations are clear. They, even with a clarification, there can be no two interpretations.
Lordship.
That you have acquired a vested right.
Lordship.
Even if there's a mandatory or what do you call it, to improve to clarify, it cannot take away your right.
Lordship cannot. But my
that is seeking to take away by misinterpreting.
Exactly. My lord, otherwise, my lord, my first plank of submission will be this is not an amendment at all. And three judges, this is not an amendment at all. That 3 point has never been amended, and Supreme Court has made it categorical, my lord, that this is not a mandatory regulations. When it is not a mandatory notification, my lord, 3.8 remains in its original language. And Lordship also will take note, this was reissued with the clarification. 2016, it was reissued, my lord, without any change of language. If their intention was, my lord, that there are some problem creation needs to be clarified in 3.8, they would have amended it. When they have reissued, they have retained exactly the same language. Secondly, my lord, I have pointed out, now my lord, in my writ petition, I have pointed out that there are a number of lecturers coming from, my lord, engineering stream. Though they do not have PhD, they have been given 9,000. Now they have answered. They said yes, they can be, they do not require a PhD. So they are not, my lord, denying, my lord, the existence of 3.8, but they are trying to restrict it to the engineering stream.
Because
they are creating a classification.
Because they are from humanities.
Yes. Now they are creating the classification. Here, my lord, I have minutely gone through 2010 and 12. There is not even by implication any kind of classification between lecturer from humanities and science and, my lord, those are from engineering stream. Had there in by an implication, my lord, they would have a scope to make a submission, my lord. There is not by implication even it is not there. So my humble submission so far, PhD, my lord, this is absolutely, my lord, not provided in the law. I do not require. If I go to stage 5, irrespective of, my lord, date of entry, PhD is an essential qualifications. They could have used the same language.
That's a different thing. Yes.
My lord. Now the question.
3.9.
Yes.
Yes.
Now, my lord, other thing, my lord, as I have submitted your lordships, other thing, my lord, so far the impugned notification up to 8,000 I was given. It's very clear. Only reason they have cited lack of PhD. They have not said about the short of course. Now in the affidavit, since they have said, my lord, I am short of course. Now, my lord, again, my lord, we cannot enter into the domain of the expert. Now, what they are saying here, my lord, perhaps they are not aware about the further clarification issued by the AICT in 2020, where they have said, my lord, that national level, the TTTR, NITTR, any course conducted by them has to be accepted. Then those approved by UGC has to be conducted. As I have laid down in my table, your lordship, the table, it is very clear and categorical, my lord. I have done 2 weeks courses. One from, my lord, NITTR in the year 2001.
2 weeks and 1 week.
No, 4 1 weeks.
4 1 week.
4 1 week. And further, my lord, I have done in 2015 2 1 week, sorry, my lord, 1 2 week course from NEHU approved by UGC. Now, further the clarification, as I have pointed out, it says anything approved by UGC to be accepted by AICT. So, my lord,
judgments you kindly show, which relying upon apart from Mr. 2020.
My lord, I am relying on 2020 because 2020 is very clear and
that is the main case.
My lord, 2020, my lord, is very clear and categorical. Very clear and categorical, your lordships. So, my lord, other thing perhaps may come to your lordship's mind, because even if my case was considered, my lord, in the year 2011, by 2011, your lordships, I have, my lord, completed 1 2 week program plus, my lord, at least, my lord, 3 1 week program in 11. That was the scenario. In 2013, my lord, further I have completed 1 week program, and in 15, further I have completed, my lord, 1 more 1 2 week program from NEHU. Now, perhaps the question what my learned friend was saying, that if you are not eligible on the date, then perhaps, because 2011, my lord, even if we leave aside NEHU and the 2013, my lord, still I qualified. Still I have, my lord, 2 1 week from NTTR and 2 1 week from again NTTR. Still I qualified. Now, your lordship, that also should not be a problem, because AICT has extended the time, my lord, for completing the courses. Up to, my lord, this is there, my lord, in the AICT regulation. In my compilation, it is there. AICT regulation 2020. Lordship, there is at page 150
of the compilation.
Of the compilation. Whether the requirement of number of short-term training, etc., my lord, it is level decision. No, there should be there is no relaxation in mandatory requirement. One-time extension has already been given 7/11/2015. So, my lord, the candidates were given. Those who has not completed, they could complete, and then they are eligible, my lord, from the date of their duration. Those other relevant notification, if your lordship wants, I can do. So, my lord, it is a case, my lord. It's not the case, my lord, that we are entering into expert domain. It is a case, my lord, the promotion has been refused to me, my lord, denied to me in clear breach of the requirements of the law. PhD is not required. I have completed the course from the technical institutions, my lord, which are acceptable. So my humble submission, my lord, I am demitting office, my lord, on 28th, your lordships. I should not be, and lordship will appreciate one thing. My CAS, my lord, these are not normal promotion. These are incentive to the teachers, by placing them in a higher pay scale, resulting in financial benefits. My lord, I am, my lord, now going after long 32 years of service, my lord. I should not be deprived when the, my lord, rules permits me clearly. So my humble submission, my lord, they should, my lord, consider my promotions and pass necessarily before my promotions. That's all, my lord. What is this?
Anything else to say, Mr. Lai?
Mate, this is your lordship. Lordship, my case, your lordship, I would rely again on the notes which I have placed before your lordship, your lordship. My first contention is that, your lordship, the rule, the notification 2012 at 1.3, your lordship, is very clear, your lordship. It says that provided that in the event any candidate becomes eligible for promotion under career advancement scheme in terms of this regulation on or after 5/3/2010, the promotion of such candidate shall be governed by the provision of this regulation. The admitted fact, your lordship, is that the petitioner became due in the year 2011, your lordship. That is after the cut off date of.
But how do you explain 3.8?
Lordship.
Where they say date of joining?
Lordship, that we have
not date of becoming due.
Lordship, that we have clarified, your lordship. If lordship kindly have my notes clarification regarding para 3.8 of AI's CTE regulation. If lordship kindly have that, and then lordship kindly turn to the next page.
Now you say that the term lecturer section grade cannot be applicable lecturer section grade in humanities and sciences. Why?
Lordship, because the point number
10 and 43.
Point number 10 and 43 of the regulation 2016 is very clear, your lordship, that one must have the PhD, and that PhD, your lordship, is an essential condition for placement to the next grade, your lordship. Point 10 and point 43, your lordship, of the regulation 2016 are very clear, your lordship. Very clear, your lordship. Because what happened, your lordship, the petitioner belongs to the science stream. Here, your lordship, in point number 10, your lordship, clarification is a master degree in appropriate subject of humanities and science with first class or equivalent at bachelor or master level for the upward, lordship. Kindly see for the upward movement as a lecturer selection grade under career advancement scheme CS, PhD is relevant subject is an essential qualification, your lordship. The requirement, your lordship, is very clear. It's very clear.
That means it's limited to humanities.
Lordship, yes. If lordship permits me, I may place a judgment of the Delhi High Court, which is almost similar, Your Lordship, with this case, Your Lordship. I think. If Lordship kindly have paragraph 4 of that judgment. May I read it, Your Lordship?
Yes.
The grievance of the petitioner arises on account of the fact that certain lecturer, including private respondent 4 and 5, who are stated to be junior to the petitioner in service but who possess a PhD qualification, have been granted the higher AGP of rupees 10,000. The petitioner, on the other hand, being non-PhD, continue to draw AGP of rupees 9,000. According to the petitioner, the present of PhD essential eligibility condition for placement is arbitrary, discriminatory, and consequently, the issue which arises for consideration in this writ petition is whether the prescription of a PhD degree as an eligibility criterion for concession of lecturer selection grade stage 4 pay band of rupees so and so with AGP so and so for grant also is arbitrary or otherwise illegal under Article 14(16) of the Constitution. Lordship kindly have paragraph 17. At the outset, it is.
So this is regarding. See, read para 3.
Stage 5.
Para 3.
Lordship.
The principal appointed lecturers by way of direct recruitment in ways so and so and so. Over here, they earn career advancement, pretty working lecture selection grade. Not dispute that they are grade 4, drawing pay band 9,000. Now, I hope this judgment does not deal with grade 5.
This will help me on this.
Who's that? Wish. No. क्या हो गया?
This is to stage 5.
Here is stage 5.
Lordship, what I mean to say, Lordship, since Your Lordship, this is an exercise by the expert, Your Lordship.
Yes, where?
Para 17, Your Lordship. At the outset, it is noted that the matter primarily involved the exercise of statutory discretion by an expert body, AICTE, in prescribing qualification and career advancement criteria for teacher in technical institution. The issue is clearly covered by the judgment of the Supreme Court in All India Shri Shivaji Memorial Society, Supra, wherein the court recognized the distinction between teacher possessing PhD qualification and those without for purpose of pay and career fall within the domain of the statutory expert, and court should exercise caution before interfering in such matter.
No, this is what exactly. This judgment doesn't cover your case. Read para 18. The private respondent, though junior and service petitioner, possess a PhD. Clarification in 41216 introduce a distinction in lecturer selection grade 4 with PhD and those without for the purpose of grant academic grade pay of 10,000. The question rises whether such distinction is arbitrary, discriminating, or violative. Now we're talking about going to grade 4. The question here, this case concerns grade 5. So, sorry. It's not applicable.
In fact, the observation in 18 helps me. You see, there is a distinction between those having in 9,000 with PhD, not without PhD for placement.
No, we reserve judgment.
Right. Oblige.
Oh, sorry, Mr. Pandey. No, 2 minutes I'll allow you. Yes.
I just want to dwell upon paragraph 3.8 and 3.9 also.
You come here.
Lordship has already seen paragraph 3.8, Lordship. And paragraph 3.9 talks about eligibility for promotion to HOD, Lordship.
No, that Mr. Sen's already shown that.
Lordship,
regarding
Lordship,
this is
Lordship, what I wanted to show was, Lordship could kindly come to page number 126. It's part of the same notification. It's part of the same notification. Here, general guidelines for fixing qualification for teachers of diploma level courses is given, Lordship.
Lordship would kindly come to 126 page number, paragraph 6.
Para?
Para 6, Lordship.
Of
page number 126 of the
of the writ petition?
Writ petition, Lordship.
Writ petition. Yes, 126.
Lordship. Para number 6, Lordship. For upward, Lordship, where is it?
126.
Page number 126, para number 6, Lordship.
Yes.
For upward movement of lecturers in scale to lecturer selection grade or corresponding stages 4 and 5 for both, Lordship, minimum qualification shall be same as prescribed for post of HOD in relevant discipline. Other guidelines are applicable as laid down in AICTE Regulation 2012 dated 8 November 2012 or in any subsequent clarification thereof, Lordship. Here the qualification for HOD is provided in para number 3.9, Lordship.
Yes.
Head of department HOD / lecturer selection grade completing 3 years of service in the AGP of rupees 9,000 and possessing
Where is it
PhD.
from?
Page number 122, Lordship, paragraph 3.9, Lordship. Paragraph 3.9, page number 122 of the writ petition.
Just the clarification.
Clarification, Lordship. Here, Lordship would kindly see it, look at page number, para 3.9. Qualification for HOD is provided, where PhD is mandatory, Lordship.
Then how can it be contradictory?
I cannot go to 3.9.
Lordship,
I don't have PhD, I cannot go.
Lordship, here, para number 6 in the clarification, it says that for upward movement of lecturers in scale to lecturer selection grade, education qualification will be similar to those for HOD, Lordship. If that is the case, for promotion to HOD...
See, so how do you reconcile with 3.8? Just read 3.8 above that.
Lordship.
Read it.
Lecturer selection grade completing 3 years of teaching in the grade of 8,000 stage 3 shall be eligible subject to qualifying conditions and API based PBS requirements prescribed by these regulations to move to the pay band of rupees so and so with the next scale of 9,000 stage 4 and to be redesignated as lecturer selection grade. However, those joining the service on after Lordship, yes. But
then this, if you see this prescription applies, then you come back to your page 126 for upward move lecture senior scale to lecturer selection grade, right? Now they will move to lecturer selection grade, correct? And the pay band of 9,000. Now it says upward move lecture senior to lecturer senior grade or corresponding stage 4 and 5. Minimum qualification will be same prescribed for the post HOD in the investment. Fine. Other guidelines applicable as laid down as so and so. The other guidelines, that means that the same thing, this exception will be there. However, those joining the service after shall be also open PhD.
My humble submission, Lordship, is that
they are having two parameters. So if you join after 5th March 2010, you would require PhD. But for those before that, they will come as one consideration, even if they don't have PhD.
Lordship, yes. Para number 43, Lordship, talks about notification of 1999, Lordship. I have this 99 notification with me, Lordship. If I can kindly have it.
I have annexed.
Yeah, annexed. Lordship, in para number 8.3, Lordship, Lordship, may kindly allow me to read it, Lordship. Where is this? Lordship.
It is there.
Which page in the compilation?
In the compilation in the top I have written.
No, in your
1999, page 43 to 61 of the writ petition. AICTE notification 99, not a regulation. This was a, my lord, by a notification. Page 43 to 61 of my writ petition.
43 to 61?
My lord.
Writ petition?
Yeah, of the writ petition. There is a compilation.
Petition 43 is a verification.
No.
Lordship, I have it, Lordship.
No, it is there, my lord. Page 40. 46, yeah. Page, my lord, sorry, 46, my lord, page 46.
Page number 6, Lordship. There.
Yes. 8.3.
8.3, Lordship. It talks about lecturer selection grid. A senior lecturer / lecturer senior scale who has master's degree and 5 years experience as senior lecturer of lecturer senior scale and has consistently satisfactory performance appraisal report will be eligible to be placed.
Have you
as
filed
lecturer.
affidavit?
We haven't, Lordship.
How?
Lordship, I have not got instruction, Lordship.
Then on what basis submitting then?
Lordship, I have got
Only one
one
study?
instruction, Lordship. Lordship, that is I have done.
No, but if it's not sanctioned by your AICTE, how?
Lordship, instruction is coming, Lordship. Lordship,
When?
I was required to place it on Monday,
After she
Lordship.
retires.
Lordship, I have asked for some more time, Lordship.
He never files in any case. Every case, my lord, at
Lordship,
last
the-
moment it comes, I have him a copy.
Lordship, I am
immediately.
constrained by the standard line given by the AICTE. Lordship, however, in this case, since Lordship has already made an observation in the order, I have asked for a specific instruction, Lordship, with regard to this point, Lordship. So, Lordship,
You have an office in Guwahati, correct?
Lordship, it's my office. If I may come back to Lordship, this will just an attempt, Lordship, to this talks about and paragraph 43, Lordship talks says that this notification will not be applicable, Lordship.
Para 43?
43 of 2016 regulation, Lordship.
Page
Senior
118.
lecturer.
Page 118. Read.
Point 43, Lordship. Sorry. Point 43, Lordship. I'm sorry.
I feel you're running around circles. Anyway.
Point 43 of 2016 notification, Lordship, specifically talks about these 99 guidelines, Lordship. And it says that this will not be applicable, Lordship.
Which not applicable?
99, 8.3. 8.3,
What he says? The para qualification prescribed para 8.3 ICTE notification dated 99 diploma
Does not apply to humanitarian science for upward movement to lecturer senior scale to lecturer selection grade, Lordship.
Becomes very confusing.
No, but I'll clarify.
Have you addressed this in petition?
Yes, sir.
This particular point. See,
Particular point,
just come
Lordship.
again.
No, what is the clarification?
Now we understand the broad thing. We understand.
Lordship.
Now only we're splitting hairs with regard to humanities. Okay, like that. The qualification prescribed para 820 by C regulation does not apply to humanities and sciences for upward movement to lecture so and so.
To lecturer
essential qualification.
Well, no, Lordship will see 43. What is the clarification regarding what? Applicability of master degree as laid down in AICTE notification 99 para 8.3. The requirement is generally, my lord, that there should be, and that was not by a regulation, that is by the notification. By the notification, it said, my lord, master degree is essential for upward movement. Now, my lord, by this, my lord, clarification, they have qualified that master degree is not required. That means even one with a bachelor degree can
But
move
is
up
it
to
MPhil, PhD essential?
Lordship, I am coming, my lord. Now here they say MPhil, PhD is essential qualification for. I am not denying that. That is, my lord, after 2010 and 2012 came into force, my lord, which are, my lord, statutory regulation, my lord. They were holding the field. So this is merely a reiteration of the fact, your lordship. But this has been, my lord, clarified in point number 10 also, that those who are entering the service, my lord, those who are entering the service, my lord, joining the service after 5th March 2010, because similar thing has been provided in 10 also, your lordship. Lordship will kindly see at 10.
Yes.
10 also they have said the
Only
similar
thing
thing.
is that your 3.8, which was earlier,
Lordship,
then clarification remained the same.
Lordship.
That's the only point.
Lordship.
Okay.
It remained the same, and it's a whole by a statute. That 99, my lord, will take into note. 99 is not a regulation, a mere notifications. A mere notification. 2010 and 2012, these are statutory regulations, subordinate legislation, my lord. Subordinate legislation, my lord, unless amended, these hold the field. So my humble submission, my lord, in the taking shelter of clarification, my lord, they cannot create confusion unless they can show that humanity and this thing stands apart, provided in the rules, and that, my lord, there is an amendment. And Supreme Court has held, my lord, 16 is not an amendment.
Anything else?
The only place, Lordship, where requirement of PhD for upward movement is not mentioned is 1999 guideline for notification, Lordship. In paragraph point number 43 says that that is not applicable, Lordship. That in this case, Lordship.
But that has since been replaced by 2010. That was, my lord, relating to 5th pay commissions. Now, so far I am concerned, my lord, I am a master degree holder. And now in 2010, my lord, following the 6th pay commission, my lord, all these, even the state government has said, my lord, 1999 do not exist. This has been replaced correctly, my lord, 2010 and 12. Now, what is holding field 2010 and 12?
It is a due date. She is due on 5/3. That is the record of date.
Joining service, my lord. Joining service.
But how can you reconcile? It says joining service.
1.3, Your Lordship. 1.3 is very clear, Your Lordship. The proviso of 1.3 is very clear, Your Lordship. There is no confusion, Your Lordship. In my humble and respectful submission, Your Lordship.
There was no confusion. A confusing report.
Lordship, I'm not confusing Your
Joining
Lordship in fact.
service and
Because
zone of
1.3 is very clear. To my mind, Your Lordship, is very clear.
Okay, let's see 1.3 again.
Lordship, kindly have 1.3. Lordship, at page 80 of the writ petition.
Yes.
Kindly see, Your Lordship. This is the notification of 8 November 2012. Lordship, kindly have 1.3 at page 80. They shall come into force with effect from the date of their publication in the official gazette, provided that in the event any candidate becomes eligible for promotion under CAS in term of this regulation on or after.
Yes.
The promotion of such candidate shall be governed by the provision of these regulations.
And these regulations provide for that you don't, if you join service before 2010, before 2000, you don't need a PhD.
No, Your Lordship. That has been clarified by at point 10 and point 43 of the regulation 2016. One should possess the PhD qualification if you belong to the science stream.
You make a chart of all these provisions. You know, the clarification, the original provision, clarification, just make a chart and just, by today you give it to the court.
Lordship, let me till tomorrow, Your Lordship, kindly. Till tomorrow.
Reserve the judgment.
Lordship, then we'll keep tomorrow, Your Lordship.
Instead of flipping here and there, you just quote it, will be easier.
Lordship, we'll do that, Your Lordship. Tomorrow, Your Lordship.
Respond number 11, the formal party, and we are not necessary party. Our name
we record, of course, we record. You'll get your appearance.
16.
Where's the instructions?
Please, Your Lordship, pursuant to directions of this honorable court, I'd like to place in the court the instructions.
Yes. So that's the end of your case.
Your Lordship, please see Annexure 7, page 12 of the affidavit. Affidavit in opposition of respondent number 5 and 6.
After an opposition?
Yes, yes. Affidavit of respondent number 4 and 5.
Yes. What do you have to, what do you want to say?
Your Lordship, according to this memorandum, there will be no further appointment, recruitment in Group D. And the last, that is subpara 5, common designation of this post. And come to the last paragraph, that is paragraph 5. Your Lordship, the last sentence. The autonomous statutory bodies may adopt the same with the approval of the competent authority as per the rules and statutes. And the respondent university has not adopted this memorandum, Your Lordship. And without adopting this memorandum, they have made appointment to the post of Group D.
See, you're caught between the devil and deep blue sea. Correct. Why? Because they can't upgrade you to Group C because you're under matrix.
But they have made appointment in Group D, Your Lordship. That is my point. They have made fresh appointment. There, I have here that in 2011.
The commission, they're not supposed Group D is eliminated. It's been what do you call it?
It is merged with Group C. But after that merger also appointment, they have made fresh appointment to the Group D post. I have the appointment letter here, Your Lordship.
When is that appointment? Recent one you got?
That is 2011. This memorandum is of 2010, and this appointment was made in 2011.
To Group D post.
Group D post. Peon is Group D post. There should be a common designation, multitasking, but it is in the post of peon.
There's only one you got.
Yes, and
how do you see it in Group C or Group D?
Peon is Group D, Your Lordship. And Your Lordship, please see my affidavit in rejoinder. Affidavit in rejoinder. Page 19.
What's the pay band here?
Peon is Group D post. So this memorandum has not been adopted, Your Lordship, by the university.
But you're serving now as what? As multitasking?
Not temporary status.
You're
level with temporary status. And please see my affidavit rejoinder, Your Lordship, at page 19. It is page 17. Type copy is at 19.
Is it correct? You made appointments for Group D. Even after the.
I don't think. Well, similarly situated.
Let me file an affidavit.
You just examine the pay band. Pay band of Group C and Group D is how much? If you won't go by the
It is specifically mentioned peon, Your Lordship. Peon is Group D.
I'll find it.
But look at the pay band. There's pay bands with regard to Group C and D.
No, but one thing is very clear. This is not that some temporary status employee has been appointed as peon. That's wrong, my lord. This is a fresh appointment. Now, fresh appointment is one thing, my lord. Whether it is Group D, other thing I will find out.
But ours is not a fresh appointment. It is.
Okay, Mr. Digitata,
and please see this.
Yes, Langstay, correct. Yes, Langstay has produced the written instructions received from the respondent number
3, Your Lordship.
3 bracket UGC stop. The same is taken on board. Next, Mr. Digitata today has produced a appointment letter purportedly made to Group D post. He submits that the university respondents, in spite of the OM dated, that is, where's that OM? OM dated where's the OM?
Just let me find out. Memorandum dated 30th April 2010.
2010.
Yes. Dated memorandum 30th April 30. April 2010.
Made the said appointment 2011 to Group D post. Submits SL to 15 instructions. You see, they can't be, once there's merger, you're not eligible, so that leaves you, I don't think this can be regularized.
Please see my rejoinder also, Your Lordship, page number 17.
Regularization, I think, out of the question, sorry.
Yeah.
61.
Public. Yes, what is this Clarenda movement? Yes, Mr. Hazarika, your matter?
Yes.
Yes. What is this? What is your case?
Regarding this is the second round of litigation, my lord. First, we have filed a writ petition, which was disposed on 14 August 2019, my lord. My lord, Annexure 1, page 21, para 4, my lord.
Page 20?
21, my lord, para 4.
Yes.
Shall I read out, my lord? At the outset, learned counsel for the parties at idem that this writ petition is well covered by the decision of this court in other similar writ petition in WPCR number 264 of Srimati Birola S. Shagba and State of Meghalaya and other passed on 14 August 2018 and submit that this writ petition may be disposed of in terms of the order dated 14/8/2018 passed in WPC number 264 2018. The reference was made to operative para 9 and 10 of the decision, which read thus. Para 9. The petition with the consent of the learned counsel for the parties are disposed of with a direction to the Deputy Commissioner William Nagar to specifically look into the issue. Next page, my lord. That is, whether any portion of land or other property of the petitioner exists or existed adjacent to the national highway which has been constructed from Tura to Shillong. In case answer shall be in affirmative, then as to whether the petitioner have suffered any damage due to the construction or in the process of construction of the road. If answer shall be in affirmative, then why their name are not included in the list as was styled list of beneficiaries by the respondent, wherein according to the petitioner the name of the other similarly situated person were included. Therefore, on similar line, inclusion or non-inclusion of the petitioner name in the list of beneficiaries has to be looked into for payment of compensation, if any, due. Number 10, my lord. The Deputy Commissioner will himself or shall constitute a committee of two senior officers to look into the issue as referred to above. The exercise shall be undertaken and completed within a period of 8 weeks. The result of the consideration, be it affirmative or otherwise, whatever permissible according to the fact situation, shall be conveyed to the petitioner. It shall be open to the petitioner thereafter to have recourse to the available legal remedies measures.
Now what is after this?
After that, my lord, in pursuance of this order, they have passed an order, my lord. Spot inquiry, my lord.
Where has the damage been quantified?
Yes.
How many trees destroyed?
My lord, the trees and other things are damaged, fencing wire, then grill gate.
How many? Where the inquiry has given the amount also?
That is according to our calculation, my lord.
No. See, to inquire into whether damage has done independently.
Yes.
By the revenue officers or by agriculture or by irrigation. Yes. What damage was assessed? Where's the damage assessment report?
Damages, that is, we have mentioned in the report on itself, my lord, inquiry, spot inquiry.
What does it say?
It is type copy, I will go, my lord.
Yes.
Second paragraph. As per notice issued by the ADC Revenue 28 April 2020, spot verification was conducted. The land measuring approximately 2,430 square kilometer breadth.
2,430 square kilometers?
No, a square
meter, I think.
Meter. It should be not kilometer, it should be meter, my lord. Which is roughly equal to 1.5 bigas, belong to one Mrs. Keller in the moment as stated by the landowner. The land fruit bearing trees, vines, battle nut trees.
Okay, forget about that. Next, what does it say?
Next, that Srimati Kalaninda also stated that the plot of land had a stream flowing through it which was buried as the land was reconstructed and leveled during the construction of national highway by the construction company themselves. This led to the destruction, uproot of the trees and destruction of a gate post, pipes and barrel. The landowner thus applied for compensation for the same from the district administration. Photograph of the spot verification is attached at Annexure 2. The compensation for the damage is claimed by the landowner.
Where's the photograph?
I have not given, my lord. They have given in the affidavit in opposition, my lord. In the affidavit in opposition.
You have given.
Yes.
They have given or you have given?
No, I have not given, my lord.
With disputed facts, how do you assess it here? Where's the photograph?
Affidavit in opposition, page number 59, my lord.
Their affidavit?
Yes, my lord.
They've
because they have made the spot inquiry and take the photograph.
No, where's the destruction?
Destruction means all they have labeled, my lord, all this thing they have labeled, all this empty places in the second.
It looks like a family photograph.
Yes, my lord. And moreover, even their affidavit also, they have admitted the fact.
No. See, Mr. Hazarika,
yes.
What this go try and see whether what you said that stream is good. This is nothing, just a picture of few people posing photograph.
Yes, but they have. This is the admitted fact. They have admitted by the state respondent itself.
Let's see from what have you said in the affidavit?
No,
the fact
I will come to.
Okay, you have.
If Lordship kindly have paragraph 9 at page 3
of your affidavit.
Lordship, yes.
Now what about the next year's annex?
Lordship, that I'll come, your Lordship.
Yes.
Lordship, kindly.
Yes.
Kindly have paragraph 9, your Lordship. Earlier, there was a writ petition, your Lordship, and a committee was constituted.
Yes.
And a report was submitted on 29/11/2018. Then, Lordship, kindly turn to the next page.
Yes.
It was found that the land of the petitioner was located outside the acquired portion. It further found that although the petitioner claimed that her footpath along with a culvert was damaged as the same was filled up with soil from outwork by the construction company, it was informed that the husband of the petitioner had requested the construction company to fill the crevice depression created by the small stream between the land of the petitioner and the PWD road. It is pertinent to state herein that there is no mention of the report. Lordship, that is on her request, your Lordship. Then, Lordship, kindly see at 5, second paragraph. It is also stated herein that the construction company BSC CJV had submitted a clarification by letter wherein it was informed that the verbal consent and permission of the petitioner was taken prior to dumping of soil. Can you see, your Lordship?
That is a false statement. We have denied, my lord.
Then
that is a false statement. They are telling that verbally in our rejoinder, my lord.
Let us see.
Para
relax. Let's see. Where's the letter?
Same thing they have not
Lordship,
issued.
kindly have the at page 37 the statement of the writ petitioner. Page 37, your Lordship.
Oh, here's the report.
Lordship, kindly see her statement. Damage of land, Shrimati Clarinda Moment, that is the writ petitioner here in your Lordship.
Yes.
Damage of land and properties as claimed by Shrimati Clarinda Moment was verified at Signage 99 plus 281 so and so. The said land was found to be located outside the acquired portion. measuring so and so, Shrimati Klanda Momin claimed that her footpath along with the culvert was damaged as the same was filled up by soil from earthwork by the construction company. However, the PWD staff informed that prior to construction of National Highway 44E, there existed a crevice between the land of Shrimati Klanda Momin and PW Road. The said depression was created by a stream flowing through it, and although one small culvert was constructed across it, the construction company was requested by Shri Julius R. Marak, the husband of the Pinat, to fill up the depression. It is on their request, Your Lordship, that has been done, Your Lordship.
That is the only mayor statement they are giving. Just
This is a report. Have you contested this report?
Yes, my daughter.
Have you filed a deputy commissioner saying this report is wrong?
No.
Have you made representation?
No.
You can't come with a bolded petition without, you haven't annexed this also in your petition.
Here we have denied that, my lord.
Denial means what?
That is,
have you assailed this? Do you have a copy
it is
of this
not part of the
with
petition
you?
also, Your Lordship.
There's nothing. Do you have a report inquiry which is done with regard to 14 petitioners?
But a copy.
You're one of them.
Because a copy have not been supplied to us, my lord. So how we will know?
Then what statement, you know what statement you made?
Because of after filing their affidavit in opposition, my lord.
I don't understand this. What kind of petitions are filed? All disputed facts. We'll give you, will dispose that petition. But then when was the construction done? Which year?
Lordship, this is National Highway 44E, Your Lordship. It must have been completed now, Your Lordship.
See, the thing is that now page 55, what note is this of your affidavit?
Lordship, just a minute.
This is the note given by her. Spot inquiry was done on 3rd of May 2023. Correct. Now what about when was this done? This other one, the inquiry report that you had submitted just now?
Just a minute, Your Lordship.
1 second.
This
was done on, when was this inquiry held? In pursuance of so and so.
May 2023.
2018.
Yes, number 54.
29/11/2018, Your Lordship.
59.
Okay. There might have been destruction, but how can you discern it now? Here's a conclusion. Your name will not find anyone in conclusion at page 38. And at that time, when you moved the court, this has already finished. This was already done. Correct.
A Lordship, yes.
Yes.
Then did you apprise the court when the order in 2019 was passed that?
No, they have not supplied that copy, my lord, inquiry. Because we are coming to this inquiry in page number 54, my lord. After our writ petition, then only they have done the spot inquiry in 2023, my lord. In page number 54, 3rd May of 2023. When they are not complied by the deputy commissioner, then only.
See this order next at page 27. On the basis of this order, your order was received also, correct? Right or wrong?
Yes.
Eight or 9, that's quoted by Justice Mittal also in this order. So don't understand really. And spot inquiry 2023, nothing is there.
Nothing is there, Your Lord. The first inquiry, Your Lordship, was conducted in opposition to the order passed by this honorable court, Your Lordship, in the earlier writ petition.
Yes, we get it. And this report also is neither here nor there. Who is this executive engineer of the report also? Nothing.
No, Your Lordship, the first report, Lordship, the first report
is comprehensive.
was by
The second
the
report is-
ESC, Your Lordship. But the second report of 23, Your Lordship, there is neither, it's not neither here nor there, Your Lordship. This has been conducted by the block development officer, Your Lordship. This is only the statement of the writ petitioner, Your Lordship, with with no tangible proof, Your Lordship. If Lordship kindly
You know,
have.
Mr. Hazarika, in my practice days, similar case are conducted. But that case, before coming to court, exact what was the damage done was photographed by the construction company. It was photographed by the landowner. This is the condition before, this is the condition afterwards. Not a photograph of them standing there in front of a fence. Whatever destruction was done was documented. And then when the matter came for the court said, yes, this has happened. And an independent committee was set up to assess the damage. Yes, not.
Earlier inquiry was done in pursuance of the 12 cases common judgment and order. Then
Yes,
done.
and your case
Then
among,
after filing our case,
see,
they have
Mr. Hazarika, you are guilty of suppression in the second case, which you're not going to do anything about right now. You read the order. Did you make any reference that your matter, that this order had already covered your case also?
Yes.
This you find 1019, correct? And see that that inspection was done when, Mr. Shulai?
Lordship.
The first inspection on 29/11/2000 and
Lordship, just a minute. 2018, Your Lordship. 29/11/2018. This is in pursuant to the direction passed in the earlier petition, Your Lordship.
12 petitioner, common judgment and order.
No. 29/11/2018.
2018, Your Lordship.
Okay. Now, you came with a writ petition after you had taken part in an inquiry.
Lordship, yes.
You came with a petition
in 2024.
No. This before Justice Mittal, that was done in 14/8/2019. 14/8/2019.
17, my lord. 2017 we have come.
Yes,
Then order is filed in
14/8/2019. You do not apprise the court, you're a lawyer only, that inquiry already been done once. Right or wrong? You mean to say on the date when the matter is disposed of, you're not aware inquiry already been conducted? Was a petitioner which took part in inquiry that took place 29/11/2018, and when the matter was disposed nearly a year afterwards, no mention was made. No mention was made whether and instead you refer to the same order by which inquiry is already done in your land. What's the court to do?
May I please, your lordship? Matter may become next week, my lord. Let me get a clarification.
It's missing
from
no
the-
clarification. Yes. And even then, the government also you have not even made those submissions in your affidavit. Statements, yes. The date of disposal, she had already taken part in the inquiry.
In the selection,
and then again
in the-
asked for the same order by which had already been implemented in her case also.
Let me get the clarification from my side, my lord.
The request of so just after 1 week. Specific date.
65.
Apply, Your Lordship.
Yes.
Your lordship, I've got no instruction, lordship. In the
No instructions.
That will be close.
Yes, MSF Harshim Young today. also has reported that in spite of her best efforts, she has been able to contact the petitioners. In constitution thereof, matter stands dismissed for non-prosecution.
68.
Ready?
Lordships. Your Lordship, I'm praying for some accommodation, Your Lordship. I'm being led in this matter by the double AG, Mr. Khan.
Mr. Khan?
Yes, Your Lordship.
I've never seen him in my court. Seldom. Yes, after 1 week.
Lordships.
On the prayer of MS, Learned Government Advocate. Due to the absence of Learned EAG, Mr. K. Khan. Mr. K. Khan?
Yes, Your Lordship.